Okay, so let's turn to drafting a bar essay, right? So we've talked about some of the background of the bar exam itself, what those components are. We've talked about planning for the bar exam. I want to switch gears a little bit and talk about how you can prepare substantively for drafting essays that will be successful on a bar exam. So I always like to start with the exact language that the NCBE gives us. I think it's always helpful when I'm trying to figure out how to attack a component of the bar exam to say, okay, well, what did the drafters say they're testing in regards to this component? So the NCBE has said that the MEE, or the essay component of the bar exam, is testing our ability to identify legal issues from a hypothetical situation, determine what is and what isn't relevant, provide reasoned analysis of relevant issues in a clear, concise, and organized manner, and present our understanding of fundamental legal principles relevant to those issues raised. Okay, so that's really what the MEE is testing us on. So what I want to provide is a few strategies to that end. All right, so first things first, I strongly recommend drafting bar-style essays in an IRAC or CRAC format. And I think at this point, most of you are familiar with what that is in terms of legal writing. It's a way of organizing our work product in a way that is very easy to draft as a bar taker, but also very easy for a grader to read because it's organized in a manner that is familiar to our bar graders as well, right? So we don't want to spend a whole lot of time on a 30-minute essay thinking about organization. If we have a strategy going in, that really allows us to focus our time on the components of drafting an essay that matter in terms of earning us points. So my advice is stick to an IRAC or CRAC format. And we're going to talk through an example of that here in just a moment. I also suggest strongly not immediately writing or typing the moment that you read through the question. I mentioned earlier, organization is absolutely key. So making sure that you have thought through the issues that need to be discussed and organize your response in a logical way just makes good sense. We want to make it as easy as possible for the bar graders to give us points, and we don't want to have to make them hunt for information in order to score points. The reason being is that for most bar essays, the bar grader is maybe spending 5 minutes reviewing your work product. The clearer and more organized your answer is, the more likely you are to earn points on that essay. If the bar grader has to really work to kind of figure out how to connect the dots in your response, that's going to potentially impact your overall score on the essay. So we want to make it clear for them. The call of the question. The call of the question is maybe the most important part of any bar essay that you're going to answer. So the call of the question is going to help you understand what is being tested. And what I mean by that is, you may recall from earlier in the presentation, I said there are 6 essays that are administered over the course of 3 hours. That's how we get to our 30-minute calculation. Those 6 essays, though, can come from, I believe it's 11 different possible subjects. So not every potential subject will be tested, but we have to be prepared to answer questions on any of those 11 subjects. We also don't know what question is being asked when we are given our MEE packet. So by reading the call of the question, it will help us identify the area of law that's actually being tested in that question. And it gives you a framework when you go to read the facts of the question as to the area of law that's being tested and how you should approach your answer. So the call to question is very important. The other thing that I would say about that is read the call to question closely and make sure that your answer, your response, just answers the question. We don't want to spend a whole lot of time talking about issues that are irrelevant or things that don't really address what the question is asking us, because on a bar exam essay, that's not going to earn us any extra points. And it's really just taking time away from the things that the bar examiners actually want us to talk about. So the call to question is very important. It's going to help you understand what's being tested, and it's going to help you focus your answer and your response, again, to maximize points. Autopsy your practice questions. So what I mean by this is that a big part of bar preparation is not only learning the substantive law, which you'll be able to do through your vendor program, but also practicing answering practice questions to make sure you're testing your knowledge of that law. So how well you understood it. Practice questions, the biggest benefit that you get from them, beyond just doing them as part of practice, is also then reviewing a sample answer or a drafter's point sheet, whatever is available to you, and honestly critiquing your own work product to see where you could have earned more points. So in other words, you're going to take a look at what you drafted during that 30-minute period. You'll take a look at that sample answer or that drafter's point sheet, and you'll see where there are any gaps in terms of your analysis. This type of self-evaluation is incredibly valuable, and it's the way that you can identify where mistakes may have been made and how to correct them before you do more practice or on the bar exam itself. Now, your vendor is going to provide quite a bit of grading as well of your work product as part of your practice. But I also think it's very valuable to take a look at that material yourself as well, because sometimes we're our own best critic in terms of seeing small things that we can very easily change or adapt in terms of our answer to help us score higher the next time. Last point here, the A in our IRAC format gets us the most points. So when we're thinking about scoring on this component of the bar exam, remember your analysis or your application, whatever terminology you use for this, is what gets you the most points. But we also have to understand the rules correctly to be able to apply them to those facts. Okay, so the R section and the A section of our IRAC answer are the two most important. So we're going to talk a little bit about strategies to help you organize your responses and kind of quickly deal with those other sections of the IRAC, so you can spend the majority of your time thinking through the rules and making sure you're applying them correctly to come to the right conclusion. Okay, so let's break down an IRAC together. So hopefully this example will help kind of illustrate those tips that I've been discussing. So when you're formulating your bar essay answer into your IRAC or CRAC, whatever format you prefer, just remember that your initial issue or conclusion statement doesn't have to be terribly creative, right? We can basically read the call of the question and model our issue or conclusion statement accordingly, right? Again, because our issue or conclusion statement at the very outset isn't worth a whole lot of points, so we don't want to expend a whole lot of time or energy drafting that part of our response. So here's an example. This is a sample call of the question that's actually from a previously bar tested essay, and I've used it to craft our example to walk through together. So Sample call of the question is, can claimant establish a prima facie case of battery against guard for the use of a stun device? And then we're told to explain. So that's our call of the question. So we very clearly know from reading this is a torts question, right? So they're asking about prima facie case of battery. It's kind of set our mind very clearly as to what's being tested. And we know that there's a guard and there's some sort of a stun device that's being used. So what we can do is reframe that and use some of the facts from the fact pattern, as well as our knowledge of the rules regarding battery, to formulate an issue statement or conclusion statement at the outset. Right? So here's our example. If we're going to format it as an issue statement, we could simply say, can the claimant establish a prima facie case of battery against the guard if the guard intentionally touched the claimant's body with a powerful electric shock through the use of a stun device? Right? So we're framing it as an issue statement there. It's kind of this open question that we're going to answer through our analysis and then come to a conclusion. If we're writing it as a CRAC, it's the same basic sentence. We're just using it more of a statement as opposed to an open question, right? Claimant can establish a prima facie case of battery against guard because the guard intentionally touched the claimant's body with a powerful electric shock through the use of the stun device. Okay, so very straightforward. We're taking the call of the question. We're modifying it slightly by connecting the dots for the reader in terms of the law that's being tested and some of the facts from the fact pattern. And then we can very quickly move on to our rules section. So let's talk about rules. Okay, so I would love to tell you that there's some great shorthand or shortcut that I can give you for crafting rule sections on a bar exam. We are going to talk about some strategies here, but there's really no substitute for just knowing the rules. And that's where your vendor program is so important, because the vendor platform is going to very clearly lay out for you the rules of law that we need to memorize to be able to apply them correctly to these bar style essays that we'll have to answer. Okay. So I do suggest that when you're starting your rule section, that you are in a new paragraph and you start that paragraph with what I call an indicator word. So it's a very clear roadmap to the bar grader that you are now transitioning from your issue or conclusion statement into your rule section. I like to use the word under. There are certainly other choices here, but I think under tends to fit with most of the areas of law pretty nicely. So, for example, you could start out your rule section by saying under the restatement, since we're talking about torts, under common law, under the traditional approach, whatever that may be, right? Whatever makes sense for the area of law that's being tested in that particular essay. But that's our indicator word, is under. Then my other piece of advice in terms of rules is start broad and then get more narrow into the appropriate sub-rules. And what I mean by that is that bar essays tend to be very tailored. There are specific sub-issues related to that area of law that they want you to talk about, and they want you to spend time analyzing. What we don't want to do is just kind of like throw in any rule that might tangentially apply to that particular area of law, because one of the ways that we demonstrate our issue spotting skills is by talking about the appropriate sub rules that apply to the issue at hand in the question. Okay, so for example, we know this is a torts question and we know it's about battery. So I'm going to start with a very broad top level rule that lays out the elements for battery. Under the restatement, battery occurs when a party causes a harmful or offensive contact with a person of another and acts with the intent to cause that contact or apprehension of that contact, right? So very broad top level, but it lays out all those very important elements to establish a prima facie case of battery, okay? Then I'm going to go into the applicable subrules. So in this example, intent may have been the issue that we really needed to discuss. It was the one that was most in question based off of the fact pattern that we read. So my subrule might say intent for the purposes of establishing a battery means that the party desires to cause the consequences of his act, or he knows that the consequences are substantially certain to result from his act. Okay, so again, we see we're starting with our broad rule first, and then we're going into our subrules that are appropriate based off of the question that was presented and the facts that we have in front of us in the question. So let's talk about this though. What if you have more than one sub-issue that's at play in that particular question? Well, my advice there then is to start with the subrule where you need to provide the most explanation, the most analysis, and then you can list other subrules that you need to talk about as well. Again, in this kind of inverted pyramid style, right? We're still starting with our broad rule first about battery. We're talking about our elements for harmful or offensive contact with the person of another, and we're talking about intent. But let's say maybe harmful and offensive contact was a sub-issue we also had to discuss in order to fully answer the question. Harmful contact causes injury, pain, or illness. Offensive contact occurs when a person of ordinary sensibilities would find the contact offensive. And then we have our subrule for intent as well. So the key here is that we are focusing in on the subrules that we know we need to talk about in our analysis. And now that we've done the hard work of organizing our rules in our rule section, we can let that be the roadmap for how we talk about the facts related to these elements in our analysis. So we're going to talk about them basically in the exact same order. You just mimic that structure. So let's talk about analysis next, right? So we've structured our rule section. We have our broad rule, and then we have our two subrules that are applicable. So now we're going to move into our analysis. So again, I think using an indicator word is very helpful. I like the word here because it's short and to the point. It indicates to the bar grader that we're moving into talking about the facts of this particular case. We've laid out the rules. We're now talking and moving into our analysis or application. Again, whatever terminology you've used to describe the A, right? How you set up the rules drives how you format your analysis. We'll walk through that example. I like this very straightforward formula, and I use this with students as well to explain how to format your analysis. What we don't want to have is just a paragraph full of facts that aren't connected back to the rules in any way, or vice versa. We have to actually marry the two together in order to maximize points on a bar style essay. So I like this formula that comes from a book called Acing the Bar Exam by Suzanne Darrow Kleinhaus. She says, always think in terms of rule with a connector word. I like the word because, which is our plus here. Fact equals our application. All right. So you'll see here in my example, that's exactly what we're going to do in terms of our analysis. So I'm starting out with our indicator word here. The guard's use of the stun device establishes a prima facie case of battery, right? So we're tying it back to the law because he intentionally used his stun device to physically impair claimant with an electric shock. So we're connecting the elements. You know, we're trying to establish a prima facie case of battery. We can do that because this is what the facts tell us. We're going to use those facts in our analysis. The contact itself was harmful and offensive because claimant suffered pain and was debilitated by the shock. So you can see very clearly, I'm tying back to our second subrule that we talked about, harmful or offensive contact. I'm making a connection with our word because to specific facts that I've pulled from the fact pattern to show that, yes, this element is also met, right? Then our last element, the guard intentionally discharged the stun device because he was seeking to stop claimant from boarding the train. Again, connecting back to our third subrule that we had regarding intent. connecting it with specific facts in terms of stopping the claimant from boarding the train, right? So one of the best tips that I can offer here in terms of your analysis is when you read just that paragraph, your paragraph of analysis, you should have a pretty good idea of what's going on, even if you never read the fact pattern, right? So if we just read this paragraph as it stands, we know that we're trying to establish a prima facie case of battery. We know that the guard used his stun device to impair the claimant with an electric shock. We know that the claimant suffered pain, was debilitated by that shock, which would be harmful and offensive. And we know it was intentional because the purpose was that he was trying to stop the claimant from boarding the train. Even without reading the fact patterns, somebody who's reading this cold would probably have a pretty good idea of what the question was that we were trying to answer and what the facts were that we used to support it. With bar essays, we need to make sure we connect all those dots. It's kind of like math, where we're always told to show our work. We always have to show our work on a bar essay to earn the most points. And then finally, for the conclusion statement, again, this doesn't have to be terribly creative. We're just going to let our rule and analysis section kind of guide our way. Reread the call of the question, make sure that our rule and analysis sections align with the conclusion that we're stating, restate your issue statement as a conclusion. So here's a sample conclusion. Under the restatement, claimant can establish a prima facie case of battery against guard because the guard intentionally touched the claimant's body with a powerful electric shock through the use of the stun device. Okay, so very straightforward example, I know, but hopefully it was helpful in showing how you can very quickly dissect a bar style essay, because again, we only have 30 minutes that we can spend on this, and organize our response in a way that's going to maximize our points. All right. I think with that, we're able to open it up for some questions. Yes?
Yes, that's correct. Thank you, Professor Kidwell. We actually do have one question in the chat. I'll pause the recording after you have an opportunity to answer this. Is there a cost for state-specific exams so that students can plan ahead budget-wise?
For the state-specific component, it depends on the jurisdiction. Some of them do have a kind of a nominal fee that's associated with that as well. And the MPRE does also. So unfortunately, each of these testing components often has a fee associated with it. So yes, when you're doing your research, I would say take a look at all of that and build that into your budget.
Perfect. Thank you, Professor Kidwell. I'm going to pause the recording, so feel free, for those of you on live, you can just unmute your microphone and ask any questions, and we'll resume the recording after the Q&A session. All right, thank you, Professor Kidwell. And I think at this point, we just wanted to share the contact information, both for Professor Kidwell as well as for Stephanie Winquist, who is here with us. And she's the Director of Graduate Law Studies, works with many of the on-campus LLM students. And she is a resource for all LLM students for questions related to just navigating these threshold bar issues as you're exploring the different resources that we have shared today. Stephanie, if you want to just unmute and just say a quick hello to everyone, that would be great.
Hi, I'm excited to join this this program, and I recognize a couple familiar faces on here. So hi, and I look forward to working with you all.
Wonderful. Thank you, Stephanie. And we have, last but not least, Monica Hayes, who is with us. Monica, if you can share some of your perspectives, having gone through this process, both as a student and navigating the DC bar, that would be incredibly helpful. Again, we've included Monica's contact information here. We're a few minutes past 12, so feel free to just share your thoughts, and any additional questions if students have those, you can always direct them via email.
Yes, of course. Hi, you all. It's a pleasure to be here. And for those that do not know me yet, so I'm a former student, as Margaret said, and I'm here to answer any questions and help you out through this road, which is not easy for an attorney. So if you have any questions on anything really related to the program or to the bar, feel free to contact me. I don't want to take much of the time, but one thing that I want to say and reinforce that Professor Kidwell said in the beginning is start prepping for the bar exam as early as possible. It is cumbersome. There's a lot of steps that you need to take, a lot of documents, translations, and reference letters, the character and fitness process. It is a long one. I knew only on the day of the swearing ceremony that my process had finished. I didn't have time to invite anyone to my ceremony because of that, because they called me in the morning to tell me that it was all done, and I started 8 months before. So with that information, please, if you feel like you want to sit for the bar next year, start prepping the year before, especially with the NCB process. Again, any questions, please feel free to contact me. I'll be glad to help you out.
Perfect. Thank you so much, Monica. So I wanted to once again thank everyone who took the time to join us live today. Professor Kidwell, thank you for organizing all of this, for sharing your thoughts. I think it will be incredibly helpful for students just getting, their first step into navigating the bar issues. I entered into the chat all of the links as well, and we'll be sharing this slide deck and the recording in each of the class sites. So I'd encourage you, probably even before reaching out to Ms. Winquist or to Monica, to just take a look at those websites, start evaluating your individual eligibility, because every situation is unique given where you earned your law degree, whether you are admitted to practice in a jurisdiction, how many years of practice you had, and whether you're looking to qualify for that academic piece based on the LLM degree. So please go through those resources, and then as you have questions, please feel free to reach out to us as well. So with that, I'm going to stop the recording and just open up for one last round of any questions.